We're going to call this estate planning definitions.
With Amanda. So we have Amanda Quesada here, estate planning attorney, and really quick, just a couple terms to give us more framework, but also all the viewers at home who might not be familiar with these terms. Amanda, what is a will?
Yeah, so a will is your letter to probate. So it's basically an outlining of your intentions that is provided to the probate court, identifying what you want to have happen at your death.
Okay, and then follow-up question, because I've heard the myth that I could grab this piece of paper, outline a little will, and just say everything goes to my wife. Does that hold up, or does it need to be formal?
No, so it's called a holographic will is what you're talking about. And basically what that means is that you've done this yourself, which yes, but it doesn't mean it will hold up, and it doesn't mean that it'll actually identify the things that you want in the correct way. And also you need to have at least 2 witnesses on there.
Gotcha, so there is more to it.
Right.
Myth busted, there's more to it, talk to Amanda. What is probate?
So probate, there's 2 types of probate. There's formal probate, which means that either you didn't have a will or there's a contest to your will, saying somebody's arguing against what you said. Probate is a court proceeding that helps basically administer your estate. So we come in with, hey, this person died, here's their estate assets. You have to identify to them every asset that they owned, and then how we're gonna get rid of them. And then if you do more of an informal, that means there was a will, and it's kind of more of administering it through the court system without a whole bunch of checks and balances, usually just making sure that you're doing exactly what the will says. And so again, you'll just have basically some normal steps, like 4 months of knowing that you're going to be in creditor period. Has to be open for 6 months minimum. And a lot of the time it's about an 18-month process just to go through. And there's a couple of fees associated with that, because anything you file with the court has a fee, and if you're using an attorney, they probably have a fee.
Gotcha.
So one of my biggest goals is to take care of that probate while I'm living, so that my children don't have to deal with all of that.
Right, so what you'd be looking for is the trust.
Yeah.
Our third and final term.
Dun,
What
dun,
is
dun.
trust?
So a trust is going to be very similar. It's going to be instead a letter to your estate and to your children and to whoever you're giving anything to. And what that does is it allows it to be a little more private. It is active during your lifetime, not just at your death like a will is. So we create the trust the day that you sign it. We put in terms of like, what does incapacitated look like? Maybe I don't want a doctor to determine. Maybe my husband should decide if I'm incapacitated. And I use this joke often, but like if Ashley comes home with 27 cats, will her husband think this is just Ashley or this is not Ashley? A doctor won't know the answer to that. They might just think she likes cats. So we can identify what incapacity looks like, have somebody take control at that point if we need. And we also put all of your assets in there now so they don't have to go through that probate process later. If a trust is done correctly, it is completely avoiding probate.
And as a bonus term, I think we just defined the threshold of crazy cat lady. It's 27 cats for Ashley, so thank you.
You're welcome.
Awesome, so that is Amanda Quesada, estate planning attorney. Thank you.
Thank you guys.